Good morning, everybody. This is Eric Becker. I am a partner at Cummins & White, and I head up the labor and employment practice here. I want to start by thanking everybody for attending today's webinar. A couple of housekeeping things before we get started. First of all, hopefully you're all seeing the slides here. We are taping this as well, so if you want to view the presentation afterwards, or you want to forward it to anybody, it should be on our website, and my website, or our website, is up there on the screen right now. The second thing I want to mention is that if during the presentation you want to pose any questions, please enter them into the chat dialog box, which should be on your screen. I'll be stopping and pausing at various places during the presentation to look at the chat questions and hopefully answer your questions. Of course, if you have any specific questions, you can email me afterwards, and I'll be happy to answer your questions. Third housekeeping item is that if you want a copy of the presentation in a PDF, please email me afterwards, and I'll be happy to send you the copy of the PowerPoint slide presentation for whatever use, to remind you, et cetera, et cetera. Happy to do that after the fact. Okay, so we're talking today about utilizing independent contractors after the Supreme Court's decision in Dynamex. And probably a lot of you have seen articles or media reports on this case. It did get a lot of attention, and rightfully so. But I will say that there was a lot of media reports that I saw, including even some blogs from attorneys, that made it sound like it was complete doom and gloom, and after Dynamex, you just better not even think about having independent contractors. And that's not really the case, as we'll see today. Certainly, Dynamex is a very, very important decision that places some restrictions on the ability to classify people as independent contractors under certain statutes. But as we'll see, the tests for independent contractor versus employee status in other contexts still survive. And that's what I really want to do today is walk through the background of all of this so that everybody understands, at least to a certain degree, what are the tests for employee versus independent contractor status on all the various statutes here, federally and in the state, and how Dynamex changes that or doesn't change that, so that you can make a more informed decision about how to deal with having current independent contractors or utilizing independent contractors in the future. It looks like I'm going to change what I said about typing in questions. Why don't you use the question box on your dialog on your screen rather than the chat box? I think it'll be more simple. Okay, so the first thing we have to do, however, before we get to our presentation, is talk about our legal disclaimer. Well, you know, I'm a lawyer, so this is what we have to do. First of all, I just want to make sure everybody understands this webinar should not be considered as providing any legal opinion or legal advice. It is really intended to provide a concise summary on the state of the law regarding independent contractor and employee status. Really, when it comes to independent contractors versus employees, there's a lot of different things that have to be taken into account. And every situation is going to be different, like most things in employment law. So you really want to make sure that if you're trying to decide whether or not somebody should be treated as an independent contractor versus an employee, that you talk to legal counsel, whether that's me or somebody else, and review the specific facts and what it may have changed in the case law or the statutes between our webinar here today and when you're asking that question, because this is an area of the law in flux, and I'm expecting going to be a lot of subsequent decisions and subsequent changes stemming from the Dynamex decision. So you really want to make sure that you do your due diligence at that time, rather than relying on what we cover here today. Okay, with that out of the way, I wanted to first summarize where we stand after Dynamex, and then kind of go into the details of the background and the case itself and what it means. So I think the fundamental question that I posed at the outset, is, can you still use independent contractors in California? And a lot of the media reports, doom and gloom, independent contractors, you just can't use them anymore. Everybody's got to be an employee. And I think the answer to that question is, yes, you can still classify people as independent contractors in California, but you have to do it with caution. And that's because this Supreme Court decision in Dynamex versus Superior Court, the focus of today's webinar, set forth a new test to determine whether somebody is an employee or an independent contractor. We're going to talk about all the various tests that have existed prior to Dynamex and how they've been utilized and how Dynamex changed that test. The important thing I want to summarize right now is that the Dynamex test, also known as the ABC test, which we'll talk about, only applies in very limited circumstances. Dynamex actually does not change the test used to determine independent contractor status in most circumstances. So in most of the areas where you're trying to figure out, okay, can this person be an independent contractor or an employee, whether that's for tax purposes, workers' compensation purposes, etc., the Dynamex test doesn't apply. The more traditional tests, which we'll talk about in a second, still apply. Now, future decisions may expand the applicability of Dynamex. I think that's what most people who practice in this field expect. Even though Dynamex is a very limited decision, they expect future court decisions to broaden the applicability of this ABC test. But as of right now, it is a very, very limited applicability. Now, the other thing that may happen is that we may see legislative action. Our wonderful legislature may decide to step in and say, we want this ABC test that was announced in Dynamex to apply in more situations. But at this point, we don't know yet. So that's kind of the summary of what I'm going to cover today. What I want to do is start by talking about definitions of employee status. So really the basic groundwork for understanding Dynamex is understanding that there are differing definitions of employee. Now, the definition of employee also has an impact on the definition of independent contractor, but what we really want to focus on at the start is, what is an employee? How is that defined? And it depends on which law is being applied. Which law is being applied to figure out, is this person an employee for purposes of that particular law or an independent contractor? So there's a number of differing definitions based on which law is being applied. For instance, there's a definition under federal tax law. So if it's being determined by the IRS, should this person have been given a 1099 as an independent contractor, or should they have been paid wages reported on a W-2, there is a certain test that is applied to determine employee status. Similarly, for purposes of determining unemployment eligibility and tax status under California law, the EDD, the Employment Development Department, has their own test on what constitutes an employee. And this comes up very often when somebody who's categorized as an independent contractor, for whatever reason, the employer stops using them and they go and file for unemployment. And the EDD says, no unemployment taxes were paid for this person. Are they an employee or are they an independent contractor? because if they were misclassified as an independent contractor, that employer is going to owe some back taxes, and they have their own test that they apply in those circumstances. There's also a test that applies when it comes to wrongful termination and employment discrimination decisions. So when somebody files a lawsuit alleging that they were wrongfully terminated or they were subject to employment discrimination, the employer might say as one of their defenses, hey, they can't sue for wrongful termination, they weren't an employee. And there's a test that's used, very similar to the EDD test that we'll talk about, in those circumstances. The same thing with labor code provisions. The labor code, various provisions, only applies to employees. It doesn't apply to independent contractors. And so when someone brings a labor code claim, there has to be a determination, sometimes at the outset, are they an employee or are they an independent contractor? And finally, and most importantly, for today's purposes, there is a definition of employee under the wage orders. The wage orders are the regulations here in California that come out from the Industrial Welfare Commission that set out things like minimum wage, meal periods, and rest periods. And there is a different definition of employee under the wage orders, and that was really the focus of the Dynamex court. So, one thing to keep in mind, under all of these things that we've been talking about, federal tax law, unemployment eligibility with EDD, wrongful term, labor code, etc., under all these applicable statutes, there is always a presumption of employment. There is always a presumption that the person, the worker, is an employee. The burden of proof, the burden of proving that that person is not an employee, but an independent contractor, falls on the party asserting that, okay? It doesn't fall on the person saying, hey, I think I was an employee. It falls on the employer. In other words, in a close call, it's always going to be found that the person should be considered an employee, not an independent contractor, because the burden of proof is always going to lie with the party asserting independent contractor status. So, as I mentioned, the definitions of employee status affect the standard for proving independent contractor status. They're kind of, both sides of the coin, right? In order to prove someone's not an employee, you have to prove they're an independent contractor. But the definitions themselves really focus on, are you an employee? Do you meet the definition of employment under all of these different statutes? So let's talk about these different definitions of employee, starting with the IRS test. Okay, this is something that a lot of people are very familiar with. It is a common law test based on multiple factors. When I say common law test, what that means is it's not set out in the IRC regulations. It's not set out in the IRS statutes. It is something that has been developed over the years in various cases. But it's a test based on multiple factors. Some of you may have heard of the 20-factor test or the economic realities test. These are the names that the IRS has called their test over the years. The important thing to understand about this test is no one factor determines employee status. It is always a totality of the circumstances. In other words, you don't just say, okay, that person meets this one factor to be an employee, and therefore he or she is an employee, and we're not going to worry about the rest of it. You have to look at all the different factors, and some are going to weigh in favor of employee status, and some are going to weigh in favor of independent contractor status, and you put it all in the mix, and you see at the end of the day how the factors weigh out in determining employee status. So the factors used under the IRS test fall into three main categories. Behavior control, okay? Does the entity, the company, control how the employee does, or independent contractor does their work, in what manner they perform their services, what hours they perform that work, etc. Secondly, financial control. How is that person paid? Does the company supply the tools and equipment and location for the employee to perform their job? Does the individual, the worker, bear the risk of making a profit or having a loss? So there's a number of different factors that go into that category of financial control. And finally, the relationship of the parties. Is there a written contract that says that the worker is an independent contractor? Do the parties believe that the worker, is an independent contractor or employee? How is that relationship borne out? Number of different factors go into that category as well, which I'm not going to go into in great detail today, but just understand, most importantly, there is going to be employee status under the IRS rules where you have a couple of main things that you see. First, the company has the right to direct and control how work is accomplished. You're telling that person, hey, I need you to do this. Here's how I need you to do it, giving them instruction and direction. Secondly, the individual does not market their services to the general public or take the risk of profit and loss, meaning they don't have to worry about, hey, if I spend too much on equipment, maybe it's not going to cover the amount of money I'm getting from my customer, and therefore I might take a loss. No, they're just getting a flat fee, and all the equipment and expenses are covered. They don't risk profit or loss. That's going to be an employee. And lastly, if there's no written independent contractor contract and the work that the worker is performing is core to the business, it's something that is part of what the business does as opposed to something that is ancillary. So under the IRS test, if you see those three broad things in terms of the fact pattern, you're probably going to end up with someone who the IRS would say is an employee and should be paid pursuant to a W-2. Next, you have the definition of an employee under the EDD's rules. So the EDD is the agency here in California that makes sure that employers pay their taxes, and they're paying their unemployment taxes and their state SDI disability taxes, and there's being money withheld for state income taxes, and if people want to get unemployment benefits, they go to the EDD. So the EDD has their own definition, similar to the IRS definition, but there are some differences. It again is a common law definition, and it's based on a case called S.G. Borrello. This is the case prior to Dynamex that everybody would look to here in California in determining employee versus independent contractor status. So under the EDD's test, as adopted from S.G. Borrello, there are more factors and a different focus. When I say more factors, they actually look at 23 different things in determining whether or not somebody is an employee or an independent contractor. And there's a different focus. The IRS looks at all 20 factors, all those broad categories equally. The EDD says, no, there's one factor that's more important than all the others, and that is the right to control. So under the EDD test, if the company has the ability, it's not whether they do it or not, it's whether they have the ability or the right in the relationship to instruct, direct, train, set hours of work, and ability to discharge at will without cause. If all of those factors are present, even if all the other factors seem to indicate independent contractor status, the EDD is going to say, nope, that's an employee. So they definitely put more of a focus on the right to control, but there's other factors that they take into account. If, for instance, there is no written independent contractor contract, the EDD is going to find that as a factor evidencing employee status. Again, if there's no risk of profit or loss, like we saw with the IRS test, if the person doesn't offer services to the public, if the parties believe it is an employment relationship, if the work performed is core to the business, all of those things, the EDD is going to say, seem to indicate employee versus independent contractor status. But the important thing to recognize with the EDD is that under the EDD rules, even if you have a written independent contractor contract and the person offers their services to the public, if you've got that right to control over how they perform their work, the EDD is going to find that they're an independent contractor. They're going to find they're an employee. So very important to, when you look at the EDD test, understand that although there's a number of different factors and, furnishing of tools and materials, where do they get their tools and materials? Other things they look at, things like if there's a continuing relationship, is this something that is for just a 6-month period or a year period? Does it go on for a long time? Does the the worker, get to hire assistants to help them perform the work? Is the work done on the premises? All those different things they're going to look at under the EDD test. But again, it's a multi-factor test. Next, I want to talk about the definition of employee under employment claims. Most of the courts have applied the Borrello test, the test that the EDD uses, to determine employee status in litigation of employment claims. So, when it comes to wrongful term, discrimination, workers' compensation, is somebody an employee for workers' compensation purposes, or labor code violations, the courts have pretty much said, we're going to follow that same test that's set out in the Borrello case. In the past, there's been a lot of cases where people have argued that there should be a stricter test for determining employee status that is more in favor of finding employee status. And the courts have always said, nope, Borrello is the test, multi-factors, that's what we're going to look at. But one thing I want to mention, when it comes to sexual harassment or other forms of harassment, it doesn't matter whether somebody is an employee or independent contractor, because the Fair Employment and Housing Act specifically covers independent contractors for those purposes. So even if someone's an independent contractor, they can bring a sexual harassment claim. They just can't bring a claim for discrimination. So I just wanted to mention that in case anybody has a question on that. Okay, I'm going to stop right here and see if we have any questions. So there's one question about printing the presentation. Yep, I will send you, upon request, a copy of the PDF, and you are free to print it out. Okay, so this is really the framework for what happened leading up to the Dynamex case. You had these various tests based on either the IRS 20-factor test or the Borrello test for defining what is an employee. But then we come to the wage orders, okay? So as I mentioned previously, the wage orders, you should all have this posted in your break room or somewhere, right? The wage orders contain all the rules governing minimum wage, overtime, and meal and rest periods. And the wage orders contain a different statutory definition of what is an employee. And that definition is based on the terms employee and employer. So all the other things we talked about previously are all based on this common law test that's developed over time. It's not specifically set out in the IRS regs or in the EDD regs, but the wage orders have a specific definition of the terms employee and employer. And if the company employs the worker, then they're going to be a covered employee. They're covered under the wage orders. So under the wage orders, there's 3 definitions of the term employee or employer. Number 1, someone who exercises control over wages, hours, or working conditions is found to be an employer. So anybody working for that employer is going to be an employee. Second, anybody who suffers or permits someone to work. So any entity that allows people to perform work is going to be considered an employer, and those people performing that work are going to be considered employees. Or lastly, to engage someone, thereby creating a common law employment relationship. In other words, going out and saying, hey, I want to employ you, you are going to come work for me as an employee, and therefore we have a common law employment relationship, also known as an at-will relationship. So there's the three definitions. The one that's most important for talking about Dynamex and how this impacts everybody is the second one, suffer or permit to work. And I want to mention here that the Fair Labor Standards Act, so that's the federal law that governs overtime, also defines employer as suffers or permits people to work. So there has been a body of case law under the Fair Labor Standards Act that the California courts look to in defining this term, suffer or permit to work, and that is what the court dealt with in Dynamex. So let me answer this question that just popped up on the screen. Is the hirer protected by a middleman, i.e. hire an independent contractor who in turn hires or employs the workers? We would otherwise fall into factor B. So I'm going to save that question because I want to talk a little bit about Dynamex first, since you referred to factor B. And then we'll answer that particular question about having a middleman. So let's talk about what this case Dynamex was all about first and foremost. So Dynamex was a company, or is a company, that's in the business of providing same-day delivery and courier services. So basically, Dynamex has fleet of trucks, or they have people that work for them with trucks or vans, and they're going out and delivering packages. Their drivers were classified as independent contractors. So they had a number of different people, some with their own trucks, some using company trucks, but they were all classified as independent contractors. Most of them used their own vehicles. Most of them paid all their expenses and insurance. So in other words, the driver was on the hook for making sure that they had insurance and they'd pay the premiums, and whatever gas, whatever else, the driver would have to pay for that. So there was definitely risk of profit and loss. The drivers were not paid an hourly rate. They were paid a flat rate or a percentage of delivery fee charged. Okay, so they would just get a percentage. If the Dynamex was charging $100, the driver would get 40%, they'd get $40. So they weren't paid a wage. Again, kind of looks like an independent contractor, right? Drivers could set their own schedules and routes and could turn down assignments. So in terms of control, the employer, Dynamex, said, hey, look, you know, we've got assignments. If they want to take them, they can take them. If they want to turn them down, they can turn them down. They really control how they perform the job. They schedule their own routes. They can decide to deliver a package earlier, deliver a package later, etc. Again, looks like an independent contractor under the Borello factors. They had freedom to work for other delivery services, although very few of them in reality actually worked for anybody other than Dynamex. But Dynamex said, hey, look, we don't mind if they go work for another delivery service when they're not working for us. So they were able to hold themselves out to the general public, and they all signed written independent contractor agreements. So when you look at the Borello factors, they hit a pretty good percentage of them that would seem to indicate they were not employees but were instead independent contractors. So how did this case get to the Supreme Court? Well, a driver brought a class action lawsuit, and this driver alleged that Dynamex failed to pay overtime, failed to provide wage statements like they should for employees, failed to reimburse business expenses, which you have to do if you're an employee under the labor code, and they engaged in unfair business practices. So basically the driver said, look, we were employees. We should have been entitled to overtime under the wage orders. we should have been entitled to get wage statements like an employee. We shouldn't have had to pay for our own business expenses. And all of these things were unfair business practices. So I want to represent a class of all drivers against Dynamex. Dynamex, before the trial court, said, hey, this case should be dismissed. There is no class action because all of these drivers were independent contractors under the Borrello test. And when the trial court finally made a determination on whether or not this could proceed as a class action, the trial court found they were employees under the wage order definition of employee and certified a class. So the trial court said, look, under the wage orders, these people fall under the definition of employee because Dynamex, you were an employer. You suffered and permitted these people to perform work. Dynamex appealed that, said, hey, whoa. The test that should have been applied is the Borrello test, not this thing about suffer or permit to work. That's not the right test. Under the Borrello test, the EDD test, multi-factors, you look at all of it in totality, and they should have been considered independent contractors. So the case made it all the way up to the Supreme Court, and the Supreme Court said the trial court was right. The ABC test is what we are going to adopt for these circumstances. The court ruled that Borrello, while could be applicable under the definitions of employee, so for instance, whether there was a common law employment relationship, that's one of the definitions under the wage orders. You could use the Borrello test, but it's not the only test for determining employee status under the wage orders because we have this definition of suffer and permit to work. And the court said that definition is applicable to determine whether or not these drivers were employees. And in order to determine whether or not Dynamex suffered or permitted them to work, we are going to adopt this ABC test. And this is a test to determine whether the individual has been suffered or permitted to work and therefore is an employee rather than an independent contractor. And the court specifically said, we are adopting this test because this really should be a broader test under the wage orders than Borrello. More people should be considered employees under this ABC test than under the old traditional Borrello test. So, the court adopted this ABC test. Let's talk about what it is, and then I'll answer that question that popped up. The ABC test says, in order to prove that a worker is an independent contractor and not an employee, the company has to prove each of the following three factors. This is not a totality of the circumstances. The employer's got to prove A, the worker is free from the control and direction of the hiring entity in performing work both by contract and in fact. So in other words, the employer's got to show, hey, we are not doing anything to direct and control how these people perform this work, okay? And it's not just that our contract says that the person is free from control. In actuality, in fact, that person is free from control. So that's very similar to the traditional test used under Borrello, okay? So fine, at this point, most employers could say, all right, I think I can meet that one. Now we go to the B of ABC. The company must prove that the worker performs work outside the usual course of the hiring entity's business. In other words, that person is performing some service or some work that is not core to the business, that is not part of what the business does, it's something ancillary. And C, the worker is customarily engaged in a trade, business, or occupation of the same nature as the work performed. In other words, the person who the company is trying to prove as an independent contractor has to be someone who is engaged in that profession or that business separate and apart from their work for that company. They hold themselves out to the public, they're performing work for various companies, and they market themselves out there. They're not just a worker for that particular company. So, if any of the above cannot be proven, the worker is an employee. That is what the court said in Dynamex. If you can't prove A, or you can't prove B, or you can't prove C, you can't prove independent contractor status, that's an employee. So it is not, and I want to emphasize this, the ABC test is not a multi-factor totality of the circumstances test. You gotta prove all three, and that's why Dynamex is so impactful. So, the question is, and this is where most employers, most companies are really saying, whoa, this is dangerous. Can you prove the B factor? Can you prove that that independent contractor is performing work outside the usual course of the hiring entity's business? So the question that was posed on the screen here, is the company protected by a middleman? You hire an independent contractor, let's say an independent company. It's a LLC, it's a corporation, and that company says, hey, we are going to provide you with people to perform this work, and oh, by the way, we are going to hire these people, and they're going to be our employees. Okay. So, is the middleman an independent contractor of the company? It depends on if that person is a true entity, a true corporation, or it's just somebody who's going through the motions and is actually an individual, and this is really just a sham to get around the law here. But if the people that independent contractor are employees, then your risk is really low, because the only person who would be an independent contractor is the person who you've hired as the middleman. And probably that middleman's not going to be performing the work. So your risk of a wage order claim is probably pretty low, unless that middleman either is hiring independent contractors themselves and not hiring those people as employees, because if they're being misclassified under California law, that liability is going to run not just to the middleman, but to the hirer. You cannot wall yourself off from liability in those circumstances. Or if the middleman, this independent contractor middleman, hires employees but does not pay them correctly pursuant to the wage orders, you would still have liability. So, short answer, hiring a middleman, hiring a temp agency, hiring, somebody who says, hey, I can bring in people and just pay me as the independent contractor, I'll pay them, does not necessarily shield you from liability, not just under Dynamex, but under the wage orders in general. Okay, so let's talk about how this test was applied in the Dynamex case. Okay, so the A factor, as I mentioned, is like the primary factor in Borrello. It's the right to control. And the court found that in the Dynamex case, any degree of control by the employer indicates employee status, even if the worker generally works without supervision and sets his or her own schedule. So, for instance, one of the things the court looked to is, did people have to wear uniforms that indicated they were employees of Dynamex? Well, if the employer has a rule saying you got to wear a uniform, that's a measure of control. The Dynamex was arguing, hey, these people have a right to reject assignments. Yeah, but if they rejected too many assignments, the employer might say, we're not going to use you anymore as an independent contractor. Again, if there's any type of control whatsoever, you're not going to be able to meet the A factor. Okay, the B factor, that's the one that's the most difficult to prove. Okay, you have to be able to prove in order to meet the B factor, the work is ancillary to the business. And the courts specifically used examples of hiring a plumber or an electrician that's going to come in and perform repairs at the building that the company is operating out of. That's a classic independent contractor. They're not if Dynamex had a plumber come into their company offices and fix something, that's not part of the driver courier business. It's ancillary. Okay, that's someone who would be an independent contractor under the B factor. But since the business of Dynamex was delivery and these drivers were performing work that involved delivering packages, they were acting in the course of the business. They could not be independent contractors under the B factor. And the C factor requires that degree of independence. In other words, you have to be able to prove that the worker independently decided to go into business for herself. It wasn't just, hey, I saw this ad in the paper, advertising for couriers. I think I want to, see if I can get a job being a courier. They have to independently decide, you know what, I want to be in the plumbing business. I want to be in the marketing business. I want to be an independent bookkeeper. And if you just merely permit the worker to advertise or perform work for others, it's not enough to meet the standard. It actually has to be shown that the worker is holding themselves out to the public with advertisements, trying to get hired by other entities or performing work for other entities to meet the C factor. So the biggest thing that the ABC test did is it took away this idea of multi-factor totality of the circumstances when determining whether somebody is an employee or an independent contractor. But the scope of that decision is limited by the following. The case was brought by the workers primarily under the wage orders. They were alleging that the wage orders were violated because they didn't get overtime. Okay? And the definitions that the court used in determining whether they could bring a lawsuit under the wage orders were based on those three things in the wage orders, specifically the suffer and permit to work test. So the important thing to understand about Dynamex, it is limited to situations only where there has to be a determination whether someone is a worker under the wage orders. So if the case or the situation involves something other than a claim under the wage orders, the Borello test, the multi-factor test, still applies. So if we're talking about, does this person meet the IRS or EDD test for payroll taxes? Are they eligible for unemployment benefits? Are they covered under workers' compensation? Can they bring a wrongful termination and discrimination claim? Can they bring a claim for labor code violations, such as, hey, you didn't reimburse my business expenses under Labor Code 2802? Under any of those claims, any of those circumstances, the ABC test announced in Dynamex does not apply. The court specifically said, we're not touching any of those things. We're not deciding that right now. So the law of the state still is Borello when it comes to all of those things. The ABC test is only applicable when determining whether or not somebody is an employee under the wage orders. So what's the practical impact of that? Let me just summarize the decision from my perspective. Here's really what the court was saying, okay? The court was saying, if it walks like a duck, talks like a duck, looks like a duck, it's a duck, okay? And I know that's an old cliche, but it's really what the court was saying. It's like, look, these drivers, they don't look like independent contractors. They're not like a plumber and electrician who have their own independent business and advertise and go to various customers. They work for this company. They're employees. Don't try to muck it up with this 20-factor test and try to get around what really is the intent of the legislature, and that is to make sure that people who are working as employees are protected by the minimum wage and overtime and meal and rest period rules. So the practical impact is it really removes that gray area in the multi-factor test where companies can make that argument all the way through litigation and, try to convince a jury that, hey, when you look at the whole balance of things, this is an independent contractor. There's no gray area because the company's got to prove all 3 A, B, C factors in order to meet this test. So what's the impact? Okay, it's really dangerous to classify workers as independent contractors if they're performing tasks core to the business, because there's no way that you can get around the B factor if people are doing something that is core to the business, okay? If your business is to, like Dynamex, drive packages. If your business is to run a warehouse, if your business is to, sell burgers, okay? People that are cooking the burgers, people that are at the retail counter, people that are stacking things in the warehouse, they're all core to the business. You really can't call them independent contractors if you want to avoid liability under the wage orders. And you really have to prove that this person is an independent business person that's actively marketing services to the general public. A written independent contractor agreement is not sufficient. So, any other questions before we talk about life after Dynamex? Were the vehicles used by the Dynamex drivers owned or leased for the company? Does ownership of the vehicle factor? Okay. Well, most of the vehicles were owned by the Dynamex drivers or leased from the company by the Dynamex drivers, okay? Does ownership in the vehicle factor? Under the Borello test, it would be a factor. Under the ABC test, I would say no, okay? Because it's really not part of the 3 ABC factors. Whoever owns the vehicle wouldn't play any part under ABC. Can you have a separate independent contractor relationship with an employee in addition to their current job to perform a different job that is not in their job description, knowing that this second task will probably pay about 2.5 to 3 times their current hourly wage? For example, if they have a different skill that has nothing to do and they have no obligation to perform under the current job description. Here's the problem. And the question really comes down to is, can you treat somebody as both an employee and as an independent contractor? Okay. If someone gets a W-2 and a 1099 from the same company, especially for multiple years, A, that's going to be a red flag for the IRS to look into it. Okay. B, there's going to be a presumption if they're an employee of the company that any tasks they perform for the company is related to their employment. Okay. C, I think most importantly, what are they doing as an independent contractor that is so different from their employment? My gut reaction, and again, this is one of those where you'd really have to look at it in detail. My gut reaction would be that would be very dangerous. Okay, that would be very, very dangerous in those circumstances. I would be very, very cautious. So how does Uber pass Test B? That is what everybody is asking right now. And the answer is, I'll talk about it in a second because it's part of my last slide. But clearly, the Dynamex decision is going to have a significant impact on gig economy companies like Uber. Okay, but let me talk about, how do we deal with Dynamex after this decision has come out? What is, again, the practical effect for companies? Okay. I think the most important thing, if you can take away one thing from today's webinar, when it comes to Dynamex, your risk is going to be the greatest in classifying workers as independent contractors if they would otherwise be non-exempt or hourly if classified as employees. Okay? And the reason is that Dynamex only applies in circumstances where people are bringing claims under the wage orders. That's claims for overtime, meals and rest periods, and wage statement claims. Or class action and PAGA, private attorney general's claims for things arising under the wage orders. And the reason why the risk is greatest is that if workers would be non-exempt otherwise, okay, hourly, then they could bring overtime, meal and rest period, and wage statement claims or class action claims. So if you call them independent contractors and they, like the drivers in Dynamex, if they were really employees, they would clearly be hourly, non-exempt. Then you're taking the risk of getting hit with a class action claim for all of the overtime or meal and rest periods, et cetera, going back 4 years, and the PAGA penalties. So basically, one thing to take away, okay, if you got people who would otherwise be non-exempt, you really need to take a hard look at calling them independent contractors. I would not classify someone as an independent contractor if they would otherwise be non-exempt, okay? But what about people who would be exempt? What about people who would meet the exemption status for administrative, executive, or professional exempt employees, for instance? The wage orders don't apply to them. So they couldn't bring a claim under the wage orders, and therefore the whole ruling in Dynamex would not apply to them, at least for now. Because remember, Dynamex only applies to the definition of employee pursuant to the wage orders. So if someone meets the executive exemption, they supervise 2 or more employees. They meet the administrative exemption. I'm not going to go into all that right now. They meet the professional exemption. They're a doctor, they're an engineer, they're a lawyer, okay? Or they're outside salespersons, because outside salespersons are exempt from the wage orders. Or they're highly paid computer professionals, again, exempt from the wage orders, okay? Then classifying them as independent contractors carries the same risks that it would have carried before Dynamex. And that is, do they meet the Borello test, not the ABC test, okay? So really when it comes to people who would otherwise be exempt employees, Dynamex is really kind of irrelevant, at least for the present, okay? Because they do not have viable claims under the wage orders. Of course, they can bring other claims. They could claim that they're actually an employee and they were wrongfully terminated. And again, it would all be dependent on the Borello test, okay? So you'd have to go back and look at all of those factors that we talked about in determining whether they're an independent contractor or an employee. And of course, it's a multi-factor test. So again, most important thing to remember about Dynamex, it really only affects your ability to call hourly employees independent contractors. Now, what's going to happen in the future? Will the ABC test be extended to other determinations of employee independent contractor status? That's going to depend on cases working their way through the court system. You know that every plaintiff who has an independent contractor case is going to argue that Borello should be replaced with the ABC test announced in Dynamex. And it just remains to be seen when a case like that might get its way all the way to the Supreme Court and what the Supreme Court might say. So Probably not for the near future, but within 3 to 5 years, it certainly would not surprise me if Borrello is supplanted by the ABC test. Second question, will the legislature mandate that the ABC test be used for other determinations like employee status under the EDD or employee status for discrimination claims? Well, there's no current legislation pending that I saw in my review preparing for this webinar. But we're going to have a new governor. We're going to have a new legislature. It would not shock me at all to see a bill introduced either late in this legislative session or maybe in it might be too late for this year, but next year's legislative session where the legislature says we want to speed this up and extend the ABC test to other situations. Another important question on whether or not this is going to be expanded. Will certain industries lobby for exemptions? There is, for instance, a very specific exemption that applies to real estate agents under the UI code, okay? The California Medical Association or some of the healthcare providers might also lobby for exemptions because it's pretty common for independent contractors to be used in those businesses. And it remains to be seen whether or not they'll have some success in getting exemptions to the ABC test for their particular industries. And lastly, how is this going to impact the gig economy? So the question was posed, how does Uber pass Test B? Okay, well, it looks like Uber can't pass Test B, okay? Could they argue, and by the way, Uber and Grubhub are both right now involved in multiple pieces of class action litigation involving wage and hour claims, okay? So it looks like from the scope of Dynamex that Uber is sunk, okay? The only thing I guess Uber could argue is, hey, our business is not to drive people. Our business is to provide a software platform. So we meet the B test because the drivers are not engaged in the same business as we are at Uber. I don't think that's going to fly. I think that the Supreme Court knew, obviously, that all of these gig economy cases have been wending their way through the system. And I think they were specifically aiming Dynamex and the rationale of Dynamex at the gig economy. So I think that ultimately Uber's really going to have a very difficult time maintaining their current model where the drivers are considered independent contractors, because clearly there's enough control exerted by Uber over how they perform their business. It's going to be very difficult to meet the A standard. Maybe they can meet the C standard and say, hey, drivers decide to go into business for themselves. They go lease a vehicle. They want to become Uber drivers. But there's no way that Uber is going to meet the B standard unless they can somehow argue that their scope of business is different than driving people. So there's a lot of what ifs that still remain after Dynamex. But everyone should take a look at how independent contractors are being used, if they are, in your business, and really take a look closely at, okay, would these people be considered exempt or non-exempt if we called them employees? And if the answer is they would be non-exempt, then probably your risk of liability needs to be lessened or eliminated by converting those people to employees. And if anybody wants to talk about how to do that, that's probably a subject for a different conversation, and I'll be glad to answer any questions that you have. So here's all the contact info. One thing I want to highlight, we do have a YouTube channel. I've been posting some short videos on various subjects in employment law. Also, you'll be able to find this presentation on our website. And of course, if you ever want to reach out, you have questions or concerns, You can reach me at my email, ebecker@cwlawyers.com, or at our number, 949-852-1800 is the regular line. I thank you all for your participation today. I really appreciate it. And if you have any questions afterwards, please feel free to reach out to me. Have a great day. Thank you very much.